I'm a lawyer, and recently I was utterly destroyed by another lawyer's opposition and was completely devastated at how badly I was positioned. But then I started looking up all their sources and realized they used ChatGPT, and it hallucinated all their quotes and citations, which they submitted to the court. Posted by u/e_luminate. I'm an attorney practicing civil litigation. Without going too far into it, we represent a client who has been sued over a commercial licensing agreement. Opposing counsel is a collections firm, definitely not very tech savvy, and generally they just try their best to keep their heads above water. Recently, we filed a motion to dismiss, and because of the proximity to the trial date, the court ordered shortened time for them to respond. They filed an opposition, never served it on us, and I went ahead and downloaded it from the court's website when I realized it was late. I began reading it, and it was damning. Cases I had never heard of with perfect quotes that absolutely destroyed the basis of our motion. I like to think I'm pretty good at legal research and writing, and generally try to be familiar with relevant cases prior to filing a motion. Granted, there's a lot of case law, and it can be easy to miss authority. Still, this was absurd. State Supreme Court cases which held the exact opposite of my client's position. Multiple appellate court cases which used entirely different standards to the one I stated in my motion. It was devastating. Then, I began looking up the cited cases, just in case I could distinguish the facts, or make some colorable argument for why my motion wasn't a complete waste of the court's time. That's when I discovered they didn't exist. Or the case name existed, but the citation didn't. Or the citation existed, but the quote didn't appear in the text. I began a spreadsheet, listing out the cases, the propositions/quotes contained in the brief, and then an analysis of what was wrong. By the end of my analysis, I determined that every single case cited in the brief was inaccurate, and not a single quote existed. I was half relieved and half astounded. Relieved that I didn't completely miss the mark in my pleadings, but also astounded that a colleague would file something like this with the court. It was utterly false. Nothing, not the argument, not the law, not the quotes, was accurate. Then, I started looking for the telltale signs of AI. The use of M-dashes. The formatting. The random bolding and bullet points. The fact that it was, unnecessarily, signed under penalty of perjury. The caption page used the judge's nickname, and the information was out of order. My jurisdiction is pretty specific on how the judge's name, department, case name, hearing date, etc. are laid out on the front page. It hit me. This attorney was under a time crunch and just ran the whole thing through ChatGPT, copied and pasted it, and filed it. This attorney has been practicing almost as long as I've been alive, and my guess is that he has no idea that AI will hallucinate authority to support your position, whether it exists or not. Needless to say, my reply brief was unequivocal about my findings. I included the chart I had created, and was very clear about an attorney's duty of candor to the court. The hearing is next Tuesday, and I can't wait to see what the judge does with this. It's going to be a learning experience for everyone. Top/relevant comments. Commenter. Holy crap. Good job double checking, and that was an insane read. He absolutely did not/does not understand the limitations of an LLM. It's very easy to do because of how convincingly wrong it can be, and how impressive it can be. With all new tech, you have instances where very intelligent people end up making very stupid mistakes because of a lack of basic understanding. I love reading stories like these. Thanks for sharing. Ops response. It was absurdly convincing. The first several pages had me dead to rights. It fell apart when, after the prayer for relief, he did the swear under penalty of perjury language that obviously didn't belong. Commenter 2. As a non-American, non-lawyer, could you explain to me where that language would be appropriate, and what the concluding sentence of this type of document would normally be like? Ops response. An attorney is an officer of the court. We just need to sign it. The oath is built in. Commenter 3. Not a lawyer either. But just to add to Ops' reply, that wording would be appropriate if it wasn't someone who's already an officer of the court, like a witness, or you or me. Then the signature section should say you're signing under penalty of perjury so as to inform the average person of the penalties for lying, which a lawyer should obviously already know. Commenter 4. I have a lawyer friend, who is working with other lawyers on cases related to IP theft and AI training. She is astonished how many lawyers on her own team, building lawsuits against AI companies, do not know that LLMs hallucinate. They had never even heard of it. Meanwhile, the law school at my own university has now introduced a module called Legal Writing with AI into the required writing course. Op adds an edit to his post. He just filed a motion to be relieved as counsel. Commenter 5. He just filed a motion to be relieved as counsel. On what basis? Op's response. He says it's irreconcilable differences with his client. I have my doubts. Op adds a second edit to his post. The hearing on the motion to be relieved as counsel is set for the same day as the hearing on the motion to dismiss. He's not getting out of this one. Commenter 6. I know from your postings that you're super excited about seeing this one go down. But I'd be really hesitant to go hard on the guy at the hearing. The facts and briefs should speak for themselves. You probably don't get a whole lot for your client by really dunking on the guy at the hearing. The court should do that for you. Or, in any case, understands what's happening and doesn't likely need you going all scorched earth to make its decision. The other thing to consider is that this other attorney may still keep practicing. You may see him again. And while you may be within your rights to really dunk on him, he may not forget you going the extra mile to really stick it to him. Is it worth it? You probably already won. It may be, but I'm not sure. Ops response. You're absolutely right. I have no intention of dunking on him. I gave the court the information it needs to reach its conclusion. There is nothing more that can be gained from making a spectacle. My main point of interest is seeing how the court approaches this. Op adds a third edit to his post. I must admit I came away from the hearing a bit deflated. The motion was not successful, and trial will continue as scheduled. Opposing counsel, who signed the brief, did not appear at the hearing. He sent an associate attorney who knew nothing, aside from saying we're investigating the matter. The court was very clear that these were misleading and false statements of the law, and noted that the court's own research attorneys did not catch the bogus citations until they read my reply. The motion to be relieved as counsel was withdrawn. The court did, however, set an order to show cause, OSC, hearing in October, as to whether the court should report the attorney to the state bar for reportable misconduct of misleading a judicial officer by an artifice or false statement of fact or law or offering evidence that the lawyer knows to be false. Business and Professions Code, Section 6086, Subdivision, D, California Rule of Professional Responsibility 3.3, Subdivision, A1, A3. The OSC is set for after trial is over, so it will not have any impact on the case. I had hoped to have more for all of you who expressed interest, but it looks like we're waiting until October. Op adds a fourth edit to his post. If you're still hanging on, we won the case on the merits. The same associate from the hearing tried the case himself and failed miserably. The OSC for his boss is still slated for October. The court told the associate to look up the latest case of AI malfeasance, Nolan v. Land of the Free, LP, prior to that hearing. Update 1 month 2 weeks later. I can't believe it's already been a month since my original post, which you can find here. The court held the OSC, and the attorney appeared in person and was plainly remorseful. He was older, had been practicing for over 35 years, and it was clear he felt bad about the whole thing. He told the court that a junior associate who was no longer with the firm had submitted the brief to him, he had signed it without looking, and was unaware of the issue until he sent a different attorney to argue the motion at the hearing. The court seemed torn. On the one hand, there was a lack of supervision of the younger attorney, the cases cited were clearly misleading, and the attorney wasn't even paying enough attention to withdraw the brief when it was brought to the court's attention. On the other hand, he was remorseful, had no history of discipline with the state bar, and had taken remedial measures, aka firing the offending attorney. In the end, the court sanctioned him $750, below the threshold for reporting to the state bar, payable to the court clerk, ordered that he send apology letters to both us and his client, and ordered that he file the proofs of service with the court. While not the absolute beating the court could have dished out based on the appellate court's ruling in Nolan v. Land of the Free, LP, which the court cited in its OSC, it was commensurate with the harm. While the OSC was still pending, we ended up going to trial, and won the case on the merits. I think that may have had some bearing on the court's ruling, as we were in no way prejudiced by the offending brief. I guess, at the end of the day, all is well that ends well. Everyone lived to fight another day, and we all learned a valuable lesson. Always check your sites. Top/relevant comments. Commenter. What's the chance he was lying about the other attorney doing it? Ops response. Doubtful. He was older, and probably had no idea what AI was, much less ever used it. Either he was a very good liar, or he was genuinely remorseful over the whole issue. The court seemed to think the latter, and I tend to agree. Commenter 2. What happened to the junior attorney? Seems the sanction was fair for the supervisor, who didn't knowingly submit an untrue brief, but the junior should clearly face worse sanctions. Ops response. I question that too. We will never know. I guess the court figured losing his job was punishment enough. Commenter 3. The real danger is getting lazy. Some lawyers might quit double-checking their work. Whole fake cases can look real enough to slip through. Then you lose trust. Once a made-up site hits a courtroom, every honest one starts looking shaky. Folks stop believing what they read. Some older people don't understand AI, and some younger people trust it too much, and the legal system needs to catch up. Then, when folks stop reading the law themselves and just take the machine's word for it, we start getting closer to idiocracy.